A very good evening to all of you. So tonight we would like to discuss constitutionalism. So this topic is quite broad, so we will have about 2 or 3 lectures to effectively discuss it. Um, so in this lecture, we are interested in understanding the concept and historical development of constitutionalism and how it developed theoretically, globally, and then in Ghana. And we're also interested in understanding the practice of it in Ghana. Before our 1992 constitutional dispensation and under our 1992 constitutional dispensation, we also seek to examine the challenges and the manifestation of constitutionalism under military regimes. As we have said time and over again, we cannot learn constitutional law without coming terms or face to face with one of the dark spots in our governance history, that is military intervention in politics. And when the military unlawfully takes over power, they distort everything. And that has its own implication for constitutional law. We also find out whether constitutionalism applies in written constitution only. It also applies even where you do not have a written constitution. And in that respect, we will be interested in exploring examples from other jurisdictions. So just some preliminary questions to ponder before we proceed. Is a constitution, be it written or unwritten, the surest way to ensure restraint on government? In other words, is it possible to put some hold, to put some restraint, to put some brakes on those who are in charge of the vehicle of governance, only where you have a constitution, or it is still possible to attain that without constitution? And the corollary of that is also that, is it possible to be able to have a constitution and yet fail in any serious enterprise of putting some restraint, putting some brakes on those who are in charge of the vehicle of governance, so as not to undermine the liberties of the citizenry? So how can a people make restraint on government effective? You might have heard the maxim that power corrupts and absolute power corrupts absolutely. And in fact, human beings as we are, in our own small corner, where you have unrestrained authority, just imagine the kind of things that you can do. So that is how we are. And for that matter, if you happen to be in charge of governance arrangement, we also need to be put under some restraint so as not to let us indulge in excesses, arbitrariness, and capriciousness. So fundamental question is, how can we make restraint on government effective? Will the existence of constitutional guarantees and legal restrictions be enough to ingrain constitutionalism? In other words, if you have constitutional tablet in which you have so many prescriptions, stipulations, and all that, are they panacea to arbitrariness? Will they by themselves guarantee limited government, restraint on government? Should there be internationalization of constitutional principles? to ensure constitutionalism? In other words, can we say that the best assurance to have constitutionalism is where at the international level there is some consensus that yes, certain principles, certain pillars, certain tenets of what amount to constitutionalism should be agreed upon so that we can use it to benchmark our own municipal or domestic practices. Another preliminary question is that are the attainment of rights, liberties, and restraint useful to a people in dire financial and economic distress? And this is quite pertinent for us, those in developing countries. That is to say that where people are struggling to make ends meet, do they really care whether those in charge of the rules of governance have restraint placed on themselves or not? So constitutionalism and fast-paced development, which should be the ideal. There's a country in Africa, you go to Egypt, for example, if you are talking about maybe some physical development in terms of infrastructure and things like that, you may say that, yes, they have made significant progress. But the question is that if we look at other things, which are there, can we really say that the citizens have their liberties, they have their rights protected? So the multi-dollar question is that, can we marry the quest for fast development and constitutionalism? Are there good bedfellows, or they are mutually exclusive? So having said that, how may we understand constitutionalism? Basically, constitutionalism is the idea of limiting governmental power in order to prevent arbitrary rule and protect citizens' rights. So two things essentially: limited government and safeguarding or protection of the liberties of the citizenry. That if you limit the powers of government, you have the best assurance that the liberties, the right of citizens will be safeguarded. So constitutionalism establishes a system to ensure that power is distributed, controlled, and held accountable. So if we take our country, Ghana, undoubtedly, the 1992 Constitution plays a crucial role in safeguarding constitutionalism by embedding the principles of democracy, rule of law, and human rights. And in fact, if you go to the very preamble of our Constitution, our people have not left us in doubt. I'm talking about the framers of our Constitution, that the kind of governance system we want to establish is a governance system in which we have protection of the rule of law, fundamental human rights and freedom, democracy, and also accountability. So the mere fact that we have even enshrined in the preamble statement of our Constitution that we want to have a governance system in which there's also accountability and probity, by itself is endorsement of the value of constitutionalism. Because if government can be held accountable, If government can be held to probity, then that is the same as limiting the authority of what? Of government. So just in a very pictorial manner, what constitutionalism actually seeks to do is to try and manage these two groups, the individual on the one hand, and then governmental power on the other. If you give too much authority to government without any restraint whatsoever, there is no safeguard for the liberty of the individual. There's no safeguard for the freedom of the individual. So how do we marry the two? How do we ensure that the liberty of the individual is safeguarded, and at the same time, government is not given unlimited, untrammeled authority or power? So constitutionalism then involves placing legal restraint on the powers of the government to prevent arbitrary rule. Arbitrary rule means capriciousness, where there are no predetermined rules, so that you have no idea as to what to expect regarding what. And whoever is in charge of the vehicle of governance will just come up with things every now and again, according to his whims and caprices. So there's no room for predictability, there's no room for certainty, because we have no predetermined rules. So that is a classical manifestation of what? Of arbitrariness. So constitutionalism ensures rule of law. That is to say that you have predetermined rules, that all of us are subject to rules, equality before the law. All of us are subject to the jurisdiction of the regular courts. It also enforces separation of powers, because if you want to place restraint on government, then what it means is that it is unsafe for you to vest or locate totality of governmental authority in one entity. You must actually create some kind of a split division, so that the entirety of governmental authority is not vested in one entity, but it is vested in more than one entity. So that is separation of powers. And then the various entities which have been endowed with various mandate, functions, and powers will stay within their particular domain. And even if we are going to have some interaction, those interactions will be a matter of achieving checks and what? Balances. So constitutionalism protects fundamental rights of the individual, because at the end of the day, that is the dividends, that if government does not have unlimited authority, if government is subject to restraint, then what it means is that freedoms and liberties of the individual can be safeguarded. So if you have written constitution, ideally, they are supposed to codify the various restraints we are talking about and provide clear legal framework for what? For governance. Now, having said all this, we would like to draw a critical distinction between constitutionalism and mere existence of a constitution. In other words, having constitution is not equal to constitutionalism. A constitution serves a descriptive or organizational purpose. On the other hand, constitutionalism is normative and prescriptive. Normative and prescriptive in the sense that it instructs us on what should be done, what should not be done. Whereas a constitution as a tablet may just give a very pictorial or very descriptive organizational purpose, as it were. It is tempting to say that, after all, is constitution not coming from constitutionalism. So why are they not synonymous? Why do not they mean the same thing? Well, as we have noted, constitutionalism does not equate to democracy. Democracy, at least going by one of the most popular senses, often attributed to people like Abraham Lincoln and so on, you'll be told is a government of the people, by the people, and what? And for the people. So if you have democratic institutions, you have usually multi-partyism, that is political parties. You have free and fair election, first term of office of those who have been elected. And all those things contribute to a constitutionalized government. That is a government which is based upon constitutionalism. And when that is paired, or that is linked with separation of powers, rule of law, and human rights, then you have a proper limited or restraint on government, and the citizens' liberty is safeguarded. So, Professor Kumado, for example, in his work, will tell us that constitutionalism refers to the governance of state according to predetermined rules that limit governmental actions. So predetermined rules means that the rules that are going to direct how governance is done are defined ahead of time. So, for example, let me look at a very practical illustration. In Ghana, barely a month away, we're having our election. Our election, we've already defined ahead of time what a candidate or what the political party must attain before we can say that the candidate or the political party has won. All these have been predetermined. It's not the case that we start the process and then somebody will now start announcing what the rules are going to be to govern that which have already taken place. No. So these predetermined rules means that they are established prior to governmental decisions and not at the time government is deciding or when government has decided. The rules are there first. So it's not just like the chicken and egg paradox. You know the chicken and egg paradox as to whether the chicken came first or the egg came first. No. When it comes to rule of law and when it comes to constitutionalism, there's no room for chicken and egg paradox. As far as governmental authority is concerned, vis-a-vis the rules which limit that. The rules which limit that are there first before the exercise of the governmental authority. And such predetermined rules are designed to restrain the exercise of power and prevent governance by whims and caprices or decrees, as it were. I'll give you a very sad example. Some time ago, I used to have a lecturer who taught me evidence in the law school. And during a Champions regime, he was the DPP, Director of Public Prosecutions, Naneja Kedako of blessed memory. And he once told us the story that he was conducting a prosecution and how the case was going, it was obvious that the defense lawyer was doing very well, so the state was going to lose. So he saw there was a certain problem with the law. So when the court closed and he went home, he quickly had those in charge of drafting, got that law, which was being used for the prosecution, redrafted. And then they got the person in charge of signing, the Champions government, to sign. Then he had it printed and put it in his suit pocket. So when he went to court the following day, and then as the case was going on, he stated boldly that, my lord, the law has changed. And what the counsel for defense is saying is not the position of the law. Then he pulled the new law out of his pocket and then showed it to the court. So this tells you, I mean, this is the very bad example, of what we are talking about. Here, in this particular case, it's like you don't have predetermined rules. You are rather trying to make the rules for it to conform to what the government wants to achieve. And that is not what constitutionalism is about. Now, the limitations we are talking about may be institutional limitation. So you can have institutional constitutionalism, procedural limitation or procedural constitutionalism, or substantive limitation or substantive constitutionalism. So let me just give you a quick example before we move on. So institutional constitutionalism, for example, when it comes to governance, it is only the judiciary which will be given the final judicial power. No matter how the government feels about anything, the government can set up a commission of inquiry and all that, but ultimately, the work or the report of the commission of inquiry will be subject to the final judicial power of what? Of the judiciary. Or no matter what legislature will do, when it comes to matters of adjudication, it is the judiciary which has been given the final judicial power. In the same vein, no matter how the court may be dissatisfied with a certain legislation, as maybe because that legislation is working injustice, or they think that that legislation is not fit for purpose, the court can only complain about the legislation, but it cannot change it. It cannot make another one. It cannot amend it, so to speak, so long as it is not inconsistent with the Constitution, because it is not the courts that make laws. It is the parliament which makes laws. So that is the institutional limitation we are talking about. Or when it comes to chieftaincy matters, if you look at the Constitution, it is quite explicit that a matter or a cause affecting chieftaincy shall not be adjudicated by the trial courts, or by the court of appeal, as it were. They are adjudicated by the Judicial Committee of the Traditional Council, Regional House of Chiefs, and the National House of Chiefs, and then appeal lies from a decision of the National House of Chiefs to the Supreme Court. So that is it. So that is another example of what? Institutional constitutionalism. And again, even if you are legislating on anything relating to chieftaincy, the Constitution says that you must go to Nananum, you must go to the Name, you must go to the various chiefs to get their input before you can legislate. Now, with respect to procedural limitation or constitutionalism, yes, Parliament has the power to make a law, but Parliament cannot just converge in the plenary and then says that we have resolved that we made this law. No. If we look at Article 106 of the Constitution, and together with the various provisions of their standing orders, there are various processes and procedures that must be complied with before Parliament can effectively exercise its legislative power of what? Of making law. So that is example of procedural what? Limitation or constitutionalism. In the same vein, the courts have judicial power, but then we have jurisdictional limits. We have jurisdictional limits, and we also have the various procedures which must be followed. If, for example, you want the court to give you a certain remedy, you must invoke the appropriate procedure. Otherwise, regardless of the fact that the judges have taken judicial oath to dispense justice, they cannot just go about and saying that this matter I see a lot of injustices, so I'm going to give a remedy, which has not been sought in accordance with the dictates of the rules of court. Again, the executive has the executive authority, as we see in Article 58 of the Constitution and all that. However, there are a number of things that the executive cannot just do anyhow. For example, the president has the power to appoint what? Ministers. But the president alone cannot appoint ministers. The president must actually appoint ministers with the prior approval of what? Of Parliament. So you have the power to appoint ministers to assist with governance, but you must comply with a certain procedure. And that is why J.H. Mensah was the Attorney General regarding the issue of whether the holdover ministers, that is, ministers who served in the first term of Rawlings-led democratic government under the 1992 Constitution, that is 1993 to 1996, yes, as to whether and who had been reappointed, as whether they needed to also go through the procedure for fresh appointment. Then the Supreme Court had to come in and say that yes, they need a prior approval, but how Parliament to do the prior approval is up to it. Again, the executive has the power to use the money from the consolidated fund, contingency fund, various public funds which are established. But the executive cannot just go about instructing Controller General or Bank of Ghana to be dishing out money. It must go to Parliament and get appropriation bill passed. In other words, the executive must have a budget statement and say that we intend to spend this on this and this and that. And Parliament must actually pass a law in the form of appropriation act, on basis of which various spending will be done. So these are some of the examples of what procedural limitation of constitutionalism. In the same vein, when it comes to substantive, that is what they call the off-limit, things that you have been prevented from doing or you are not supposed to do. So I'll give you a typical example. If you look at the Constitution, for example, there is explicit provision that Parliament, if you look at Article 3 of the Constitution, Clause 1, Parliament shall have no power to enact a law establishing a one-party state. This is quite pivotal. And yet you may even wonder, if you look at the very beginning of the Constitution, the first 3 articles, you encounter that provision. We've not even gone to chapter 8, where the executives are actually addressed. We haven't gone to chapter 8? Yes, chapter 10. We haven't gone to chapter 10, where the legislature is addressed. And yet, in Article 3, there's a clear warning being given that, quote, Article 3, Clause 1, Parliament shall have no power to enact a law establishing one-party state. No power. So that is substantive constitutionalism. Despite the fact that Parliament, according to Article 93 and related provision, yes, you have the legislative power of Ghana. and legislative power of Ghana. So if you look at Article 93, Clause 2, subject to provision of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. So one would say that if you're talking about arms of government, we have the executive, legislature, and judiciary. So legislature is supposed to make laws, and legislature is having the legislative authority. But if you come to Article 3, we are told that despite the fact that legislature has the legislative authority, they do not have power. The legislative authority cannot be used in a way which will make a law which will turn Ghana into one-party state. Of course, recalling our bitter experiences from the first Republican Constitution, Nkrumah and his CPP-led government, where they succeeded in passing a law to make the CPP the only legitimate party in Ghana. We do not want to go back to that. We want multi-party democracy. Yeah, so to have this restraint that we are talking about in constitutionalism, there's a need for an independent judiciary. You must have independent judiciary before this restraint to make what will make sense. So the judiciary must be protected from undue influence from the executive, legislature, and other centers of powers within constitutional framework. And this is particularly so in Africa or the third world. Remember the former president of United States of America, President Barack Obama, when he came to Ghana, he once made the point that what Africa needs is that we need a strong institution and not strong people and so on. So, for example, we need independent judiciary, which will not be under the armpit of the executive or the legislature, as it were. There's an interesting work. Professor Akumado gave this public lecture, Constitutionalism, Civil Liberties and Development. If you go to the library, GIMPA, you find it, or you go to University of Ghana School of Law Library, you get a copy on a file. If you request it from the librarian, then you read it. And also, the work by Professor Nyabozi, Constitutionalism in the Emergent State, is also a very good work. If you read the first chapter, it will illuminate your appreciation of constitutionalism further. So with respect to how independence of the judiciary can actually strengthen constitutionalism, scholars like Henkin have talked about the fact that the method of selecting judges, the tenure of judges, and the conditions of service are crucial in ensuring independent judiciary. So oftentimes, when you talk about the independence of the judiciary, we also forget about the other important aspects. The budget of the judiciary, how are they dealt with? Because that is also a veritable area, a fertile area, where other organs of government can manipulate and actually undermine the independence of the judiciary. In fact, the role of independent judiciary in having constitutionalism cannot be overemphasized, especially when we recall the case of Marbury and Madison. And I asked you to read the case of Marbury and Madison. So I'm quite confident that you have read it. And in Marbury and Madison, those who were good students and listened to their lectures and went to read it, you have noted that Chief Justice Marshall, in his very clever interpretation, which led to assertion of the power of the U.S. Supreme Court to subject legislative and executive action to judicial review made the point that if you have a written constitution, then the fact that the written constitution exists is an implied recognition that powers of governance, powers of lawmakers, powers of the executive must be limited, as it were. And if that is to be the case, then there must be an organ whose remit or whose competence is to make a determination as whether the various organs or the various arms of government are staying within the province or the scope of authority which they have been given under the written constitution. And it was on basis of that that he was able to accept that the Supreme Court has the power to play the role of the referee and make a determination as whether the constitutional domain assigned to the various arms or organs have been exceeded or not. Yes, I see a hand up. Please, you have to write your name before I'll call you. Write your name, right? I'm not dealing with what do you call the names of phones. I'm dealing with my students. So write your name so that I can call you if you want me to call you. So iPhone, put your name down so that I'll mention your name and release them. Okay. Maybe a little bit of a historical excursus into development of constitutionalism. Well, if you look at the literature, some will go to even ancient Greece and Rome and all that, but we don't need to go that far. It suffices to say that if you are to use the English tradition, you go to England and Wales, which has one of the long, lasting, democracies. The one who has raised his hand up as iPhone, put your name there. Every student must put his or her name there so that I know students who are in class, okay? If you want me to listen to you, you have to hear that advice. So if you take the UK, for example, they had the monarchy for a very long time, and there were times that they had called absolutism. Absolutism in the sense that the power of the king or the queen, depending upon whether it was a male or female who sat on the throne, was unquestionable and was so powerful. But you notice that in the course of the history, there were various revolts, and including some glorious revolution and all that. And at some point, the king had to make a concession regarding certain freedoms and liberties and guarantees. And you might have heard of the Magna Carta, when a deal was reached between the king and then the commoners. And also, later on, you see how the American Revolution will also kick in. And in that American Revolution, the famous Declaration of Independence will be made, and certain freedoms and liberties were mentioned in the Declaration as belonging to all people. And for that matter, if government is established, government is supposed to safeguard those liberties. And the government is not able to safeguard that, then the government will have lost its legitimacy, as it were. But we don't need to overspend ourselves in trying to establish whether it is the English constitutional history to which we owe the idea of constitutionalism to, or to the American constitutional history. Whatever it is, the various historical developments all contributed in one way or the other in shaping the doctrine we called constitutionalism. Yeah, so I have talked about the fact that initially there was absolutism, and meaning that the monarch was so powerful, and that generated tensions, which led to near anarchy, so that the monarch's hands were forced to make concessions so as to reduce some of his powers. And that was the beginning of what we call limited government. So the commons, that is, those who are just the barons and the serfs, who just represent like the masses, were so supposed to serve as a check on the power of the crown by restraining the exercise of such powers. And this eventually led to development of a governance structure that recognized an official position. So if you go to, that is the beginning of the British Parliament practice. So you have like the government party and then other parties opposition. Again, from the beginning of the common law, going back to the 11th century, the famous 1066 Norman Conquest. If you look at how the common law courts have evolved, you notice that by and large, they have been very independent, and the independence have also ensured that the crown was not acting arbitrarily. And in fact, if we look at things like what we call prerogative orders, okay? Prerogative orders. So if you look at the Article 33 of the Constitution, for example, the remedies which are given where there are allegations of, let's say, infringement of fundamental human rights and freedoms or some other administrative injustice. You hear about the rate of certiorari, you hear about the rate of mandamus, quo warranto, habeas corpus. All those are what we call the royal prerogative rights. So, for example, where someone has been given power or an inferior adjudicating body has been given power, and let's say that the power was being abused, depending upon the type of abuse complained of, one of those prerogative orders may be deployed. If, for example, you are official and you're exercising authority, which you do not have authority to assume or exercise, they can have quo warranto. Quo warranto means that by what authority are you doing that? You can have quo warranto directed at you. So this limited or the limitation on governmental power, which is started variously through English history, eventually would also spread to other parts of the world. We've mentioned the American independence and the Declaration. That is the famous statement that they made in 1776, which is quite instructive. So I quote, "When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold this truth to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is a right of the people to alter or to abolish it and to institute a new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and unhappiness, unquote. So this is the famous American Declaration of Independence. And at the beginning of the course, I mentioned something called social contract theories, by John Locke, J.J. Rousseau, Thomas Hobbes, and then the Mills. And these social contrarian ideas are what actually also influence the American Declaration of Independence, especially when they make the point that the fact that human beings are given certain rights by their creator are self-evident. And they mention life, liberty, and pursuit of what happiness. And the basis for having government is for government to ensure that the governed will have their God-given rights actually protected. So some of these developments actually heralded the various struggles which culminated in constitutionalism spreading to other places as it were. So if you wanted to do like maybe some kind of like a timeline to understand how constitutionalism developed, we have the American War of Independence, the 1776 to 1787, the French Revolution, Restoration period in France, the German Union, French Revolution, creation of the Dominion of Canada, the Revolution of 1848. So all these various historical events in various parts of the Western world culminated in shaping the convention or the concept we called constitutionalism. So, as I said, the fact that the empire expansion of Britain following Industrial Revolution definitely also led to the spread of the idea of what constitutionalism, as it were. Yeah. So I'll pause and take one or two questions. But as I said, put your name there, then I will allow you to speak. Yeah. So you raise up your hand. I will release the mic for you. Okay, move on. No question. Good. So let's unpack the concept of constitutionalism further. Uh, Thomas Jefferson re-echoing some of the well-known sayings which have become cliche. Then he said that my reading of history convinces me that most bad government results from too much government. In other words, too much government means too much power. If you give too much authority to a government, then there's a high propensity that that government will be a bad government. So either you limit government or government limits you. Simple as that. So you limit government so that liberty of the citizen is safeguarded, or you don't limit government. And then if the government is so powerful and has untrammeled authority, then the government will now limit you. So power tends to corrupt, and absolute power corrupts what? Absolutely. And that is why there's need for limitation. And of course, uh, Montesquieu had also previously made such observation that power corrupts and absolute power corrupts what? Absolutely. Yeah, so as we have noted, the primary aim of constitutionalism is to ensure that powers exercisable within the state are well defined, and holders of the powers of state are limited by what? By law. You do not want any ambiguity at all. There should be clear idea as to who has power to do what and how is it to be done. And of course, if you look at what is going on in our country now, we are having uh, constitutionalism being tried in some way. So right now, there's that kind of clarity. Is it the Speaker of Parliament who is supposed to tell us whether certain developments by MPs outside Parliament, 3 or 4 MPs, saying that in the coming election, they are not contesting on the ticket of the party on basis of which they got elected into the current parliament, that they are going in some other way. Or those who were elected independent in current parliament, they said that no, you are falling in love in one of the political parties. So next election, we are not going alone. We are going with them. And the speaker makes a determination that if that is so, then they are deemed to have crossed carpet and their seats have become vacant. And then there's an issue. Is it for the Speaker of Parliament to make such determination, or is it for the court? And if it's for the court, is it for the Supreme Court to approach it as a matter of constitutional interpretation and enforcement? Or is it a jurisdiction which is reserved for the High Court? So in this scenario, you see constitutionalism being tested in the crucible in one way or the other. But as whether constitutionalism is adhered to in a country or not at any given period of time is relative. So so we can say that the governance activities should be viewed as a spectrum, right? As a spectrum. On one extreme end, we have a totally autocratic regime, and at the far extreme end, we have extremely restrained regime. So it's like if you like a sliding rule. A sliding rule, two extreme, one extreme. The further you go on the, let's say, the right, it means that you have extremely restrained regime. The further we go, let's say, on the left, it means that you have, let's say, autocratic. That is a regime which is not restrained in any way, so to speak. And for that matter, it enjoys absolute power. So therefore, constitutionalism is an ideal which a society or a country should aspire towards. So maybe just briefly, we would like to explore some philosophical influences or some of the philosophical underpinnings of what we call constitutionalism. although we have alluded to them indirectly in the various expositions that we have been given. But the point needs to be made that various thinkers have made contribution towards the theoretical foundation of constitutionalism in various ways by exploring the nature of authority, individual rights, and the role of government in ensuring justice and security within society. So, for example, Lord Acton, a British historian and a moralist or moral philosopher, once said, "Power tends corrupts, and absolute power corrupts absolutely." And a statement like this reflects a fundamental concern in constitutionalism regarding the dangers of unchecked political power. That if political authority or power is not checked in any way, then you are going to have corruption of what? Of power. So we may recall our friend Thomas Hobbes, his famous work, The Leviathan, when he propounded his understanding of what is known as the social contract theory. So in 17th century, when Thomas Hobbes wrote his work, The Leviathan, he posited that human beings in their natural state lived in a condition of constant war and chaos due to selfish interests. And what did he mean by this? The fact that there was no limitation on anyone, and it was like the mind was right. If you could bully your neighbor, you bully him or her, and you had your way. Meaning that if you are weak, you could just be exploited, you could even be killed by a stronger person, so long as that will serve his or her interests. So, to avoid this miserable state in which life was brutish, nasty, and short, it was necessary for individuals to enter into a social contract by which they surrender their absolute freedoms to sovereign authority, be it a monarch or government, in exchange for security and what? And order. So this concept laid the groundwork for what in modern times we call constitutionalism, as it advocated for the establishment of government based on mutual agreement, while the state, as long as it provides protection and ensures common good, can exercise legitimate authority. Meaning that if the state is not able to ensure law and order breaks down so that anybody at all can go to your house or just pounce on you, beat you, take your property from you, or do anything, then those who were given powers of governance have lost legitimacy, and they don't have to be in charge of government again, as it were. Another social contrarian, John Locke, he did his two famous work, the two treatises of government, and he developed Thomas Hobbes' ideas further, but some departures. John Locke believed in the fundamental reason and tolerance of human nature, and made the argument that individuals possess inalienable right to life, liberty, and property. So those of you who later will do intellectual property rights, I mean, you do like law, property law in general, you notice that a Lockean idea of property is quite important. So he takes a view that yes, God has God has created all of us. All of us are put into nature. Now, as individuals, we may exert ourselves, right, We may exert ourselves, spend our energies and time and resources, and reduce part of nature. We miss part of nature out of our sweat. And once we've missed part of our nature out of our sweat, be it a farm, be it a house, or anything, then in that case, because you have applied yourself and you've added something to it, what has emerged is not just what was originally nature, which everybody could lay claim to, but now you have mixed it with your labor. And for that matter, you have a property in it. And if you have a property in it, you are entitled to have that interest protected from other people. So you needed the government, you needed the state to grant that kind of protection or that kind of security. So Locke's nation idea of a government being formed to preserve this right, that is the property rights, among other things, or natural rights of property, influenced liberal constitutionalism, and which in itself emphasized the limits of governmental power and the need for a system that protects individual freedom through checks and balances. Another social contrarian, J.J. Rousseau, or Jean-Jacques Rousseau, he also contributed to what we call the social contract theory. And Rousseau, advanced the idea that in the state of nature, humans were noble and live freely and harmoniously. However, development of private property and social inequality led to corruption and conflict. And for that matter, Rousseau argued that the legitimate political authority should arise from collective agreement or general will of the people, where individuals give up their individual rights for the common good. So we, as individuals, you have your will, I have my will. And Rousseau was saying that because of general insecurity and perversion which emerged when some people were able to acquire property and others were not, in order to ensure safety of all, it was necessary for as individuals to surrender our individual will and merge it into the collective will, so that when the collective will is exercised, impliedly our individual will is protected and our interest is what is saved. So that was the thinking of J.J. Rousseau. So his philosophy actually advanced the idea of popular sovereignty, and that became element in the development of democratic constitutionalism. So, and also if you take like representative democracy, all of us, we've come together, we've elected Mr. A or Madam B to represent us in government. So when Mr. A or Mr. B decide, it's not just Mr. A or B who are decided, but it is our collective will which is reflected in his decision. And for that matter, our individual will is also reflected. Yeah, so these are some of the ways in which philosophically, the idea of constitutionalism came about. So in modern times, the takeaway is that constitutionalism rests on two main pillars. First, the existence of certain limitations imposed on the state, particularly in its relations with citizens, based on certain clearly defined core values. That is one pillar. And the second pillar, the existence of a clearly defined mechanism for ensuring that limitations on government are legally enforceable. That is why you talk about the independence of what? Of the judiciary. Now, if we look at the literature on constitutional law, various text writers have also given their own understanding or reflections on constitutionalism. So at this stage, we have a quick excursus or survey of some of the ideas of scholars who have written on constitutionalism. So if we take the Smith, for example, a famous constitutional law author, he wrote about constitutionalism in the following ways, quote, "The idea of constitutionalism involves the proposition that the exercise of political power shall be bounded by rules prescribing the procedure according to which legislative and executive acts are to be performed and delimiting their permissible content. So therefore, constitutionalism becomes a living reality to the extent that these rules curb the arbitrariness of discretion and are in fact observed by the wielders of political power. And the extent that within the forbidden zones upon which authority may not trespass, there is significant room for enjoyment of individual liberty. So these are how somebody like the Smith actually explained constitutionalism. And then just before we look at, let's say, another scholar, he made the point, and I want to refer you to Article 296 of our Constitution. If we look at Article 296 of our Constitution, can somebody read that for us? 296 of our Constitution. 296. Okay, if I'm not, let me take it for you. Why in this Constitution or any other law, discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And C, where the person or authority is not a judge or other judicial officer, there shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provision of this Constitution or that other law to govern the exercise of discretionary power. So Article 296, for example, is just another indication of how committed we are to have constitutionalism. The idea that there should be predetermined rules, so that even where people are be given discretionary power, you don't want them to have like a blank check to do whatever they want. They must announce the rules and guidelines which are going to guide the exercise of the powers or the authority that they have been given. Similarly, another scholar, Carl Frederick, he also wrote about constitutionalism in the following words, quote, "Constitutionalism embodies the simple proposition that the government is a set of activities organized by and operated on behalf of the people, but subject to a series of restraints which attempt to ensure that the power which is needed for such government is not abused by those who are called upon to do the govern," unquote. As we have said, the same ideas which these scholars are putting in different words. So Frederick would argue that constitutionalism should be understood as an institutionally based, just like how we explained institutional constitutionalism or limitation, interactive system for deliberating the meaning and legal application of the norms of a political community. And Frederick will make the point that the idea of restraint is not something recent. It developed from medieval notions of natural law, which was considered superior to any human laws and the Christian doctrine of personality. Later on, when you do legal philosophy or jurisprudence, you'll be taught natural law school and legal positivism. And the natural law people makes the point that there are certain hard principles of morality to which man-made law or positive law must approximate. So therefore, if positive law or man-made law is not in conformity with the dictates and tenets of these higher principles of morality called natural law, then that will not be a good law, or that may not even be law at all. So that is the argument of the natural law. And Frederick is trying to make the point that constitutionalism is actually foreshadowed or was anticipated in natural law thinking. And of course, our own, my teacher, Professor Kumado, will make the point that constitutionalism may roughly be defined as the art of providing a system of effective restraint in the exercise of governmental power, as we have been discussing. And for that matter, Professor Kumado made the point that constitutionalism is not the same as what democracy, but the existence of democratic institutions may be indicative of what growing constitutionalism. And he also make the further point that the mere fact that you have constitution is not enough, because the existence of a constitution is only an enabling act which sanctions governmental fiat. You can have a constitution and the government will be acting according to the constitution, and yet you will not have constitutionalism, because having constitution alone is not a panacea to arbitrariness. And he rather argued that the people, the polity, the governed, the particular society must have in themselves what we call a certain ethos, a certain belief in the idea that the power of government ought to be restrained. So the people themselves, and that is why Ghana, we take the preamble of our constitution. We said that we want to establish a government which is based upon accountability and probity. So clearly, we have made our intention clear that we do not want to have a powerful government. You don't want to have a government which is unlimited. You don't want to select or elect a government to sit on our head, as it were. Well, we also have some people who are a little bit cynical about constitutionalism, and one of such cynics is Walter Hamilton. Walter Hamilton will make the point that constitutionalism is a name given to the trust which men repose in the power of words and grows on parchment to keep a government in order. So that is how I know, of course, just trying to be a little bit less reverential towards the concept. And then we also have Jeremy Waldron, who also had a skeptical view about constitutionalism and will write about it in the following ways, quote, constitutionalism is many ways quite uneasy with or hostile to the idea of popular government and quite willing to neglect or sideline important tasks such as democratic empowerment. Constitutionalism is just a pompous word for various aspects of constitutional law or the study of constitutions. Yeah, so that is a very low view, but that is not important as it were. So if we take, Professor Kumado and other scholars have made the point that having a constitution itself is not enough to give you constitutionalism, or even just the use of the word democracy, merely speaking, will not give you what we're talking about, especially if we take countries like Democratic People's Republic of Korea, North Korea, for example. Yes, they didn't have democratic in their name, but are they democratic? When was the last time that we heard that they were having elections to select their head of state or head of government? Or even if they do at all, is it something which is really free and fair? It's not just stage managed, in order to give a semblance of some democratic experience. So a question may arise then that this democracy we are talking about, what is it? Of course, we know, as somebody said, that if I cannot define what an elephant is, when I see one, I can point to one that this is what, as an elephant. So even if you don't want to engage in the debate of what is democracy or what is not democracy, so far, having lived in our 1992 constitutional dispensation for the past 3 decades, we have some reasonable idea of what constitutes democratic governance and what does not. But by and large, there is a consensus among respectable body of scholars that a government can be called a democratic one if it is popularly based, rests on the consent of a government, which consent is given in universally free election, and which provides a mechanism for the government to change the governance in the event of dissatisfaction in their performance. So, if you apply that to Ghana, we are certainly democratic because we go to elections, nobody forces anyone. We elect our leaders. If after 4 years we are not happy with them and we want to change them, we have the right to do so. If we want to retain them, we have the right to do so. But we also have to remember that the mere fact that a government is popularly elected does not necessarily make it a constitutional one, and does not necessarily also bring about constitutionalism. So let's keep that in mind. So therefore, a constitutional government and a democracy may not mean the same thing at the same time. But in our contemporary world, it is true that a constitutional government is more likely to be a democratic one. Because if you are to do a survey, you notice that even if you have constitutional government, which are not democracy, they are in the minority. If you look at the number of countries in the world. So can a country have constitution without constitutionalism? Yes, it is possible for a country to have a constitution without constitutionalism. And if I'm to ask you to name examples, I'm sure you'll give me a legend. So what is at the heart of constitutionalism? We have used various words, and the reason for so doing is that if you are learning constitutional law, there are certain basic concepts, doctrines, or ideas which you must get right. And once you get right, all the rest are easy because all the rest will fall into places. Now, as you notice, second semester, we are going to spend almost all the time discussing various segments of actual constitutional law in Ghana. The provisions of the constitutions, the history behind them, the rationale, and operational difficulties that we've encountered, and the debate for reform. Now, all those things will be properly appreciated where you have a firm grasp of constitutional theory. In constitutional theory, we're talking about constitutionalism, separation of powers, rule of law, including what they call the judicial review and judicial independence. So once you have proper graphs of this, then the rest are relatively easier, because the theoretical background will let you know the implication of certain constitutional choices which we have made in our constitutional tablet. So if you look at our own case, Professor Sari against the Attorney General, the point will be made, which reflects what we have been talking about, that constitutionalism is about controlling, limiting, and restraining the power of the state. But we have to remember that in talking about constitutionalism, first, constitutionalism is by no means a static principle. It's rather dynamic. It evolves for society. Just as society is not static, society is dynamic. Society is evolving every now and again. So, constitutionalism is not an event. It doesn't just happen. It's happening. It's growing process. And that is why we said there is a spectrum. And the core elements which we have identified in constitutionalism are bound to change as better ways are devised to limit government and protect citizens. So you notice that so many tools of putting restraint on governmental power have even developed, let's say, the last decade in our country, which previously we didn't have. Let's take something like Freedom of Information Act. You can file freedom of information requests in order to subject government to some transparency as part of making them what? Accountable. Now, there's even a talk about e-gov, deploying digitization in governance, in which government is supposed to come to the doorstep of the governed. And just at a click, you can hold government to accountability in one way or the other. Another point worth bearing in mind is that the presence and institutionalization of core elements do not necessarily guarantee constitutionalism. The mere fact that we have the things that we talk about themselves will not be a bulletproof against arbitrariness. However, having those elements gives hope, or they give prospects for constitutionalism to happen. Where those core elements are absent, then certainly there's no hope. Then everything is bleak as far as constitutionalism is concerned. So, put differently, the core elements we have mentioned enhances the chance of constitutionalism. So what are these? Separation of powers, rule of law, judicial review. These are all essential elements of what? Of constitutionalism. So let's have a brief appraisal of constitutionalism in our country. So we'll look at the post-independence era. After we attain independence, how did we fare as far as constitutionalism is concerned? And I also look at the dark ages when we were under military rule. And we look at constitutionalism under that era. And we also look at constitutionalism when we restored democratic constitutional rule. So with respect to post-independence era, there are a few cases we would like to explore to give us an insight into how we fail as a people in our quest to put limits, restraint on governmental power. So I'd like all of you to read the case of Lardin against Attorney General, Balogu against Edusei. And of course, I've told you to read the full judgment of Re Akoto and 7 others, and especially the written submission of J.B. Dankwa and also the Attorney General. I want you to read that. And if you take the G&G, Jando and Griffith, Volume 2, you find all these beautifully reproduced there. And of course, look at the case of Wari against Oforiatta and others. Now, if you look at the 1957 constitutional arrangement, we have some restrictions or some effort to put restriction on powers of government. So if you look at the constitution, the independent constitution, for example, you notice that Section 7 provided that the assembly, when I say assembly, the National Assembly, Parliament used to be called the National Assembly in those days, can pass a vote of no confidence in the government, which will lead to the fall of that government. So that was at least good, meaning that if the government was seen as not living up to expectations, something could be done. Again, if you look at Section 32(5) of that Constitution, it also gave the Supreme Court the power to question validity of laws passed by Parliament, meaning that there was some some judicial review or some judicial oversight regarding the work of Parliament. Another restriction was also that creation of regional assemblies. If you wanted to create regional assembly, no, the regional assemblies were like now we've scrapped the regional assemblies. We just have the regional coordinating council, which is really not assembly as equivalent of the maybe the municipal and then the metropolitan assembly and so on. Now, if you look at Section 64 and Section 33 of the 1957 Constitution, you notice that if you wanted to create regional assemblies, the bills which we're going to pass to do that needed to be passed by a majority in that region, meaning that the respected regions needed to give a certain majority before you could get the process progress. Another restriction we had in our 1957, let me tell you the reason why we are giving you this overview of restriction in the 1957 Constitution is that in few years later, we are going to see a reversal of all that, and we establish more or less an unlimited government in Ghana. So that is where we are getting. That is why we need to understand what the situation was when we had independence and what it will be some years later. There was also restriction on compulsory acquisition of private property and the requirement for payment of compulsory for compensation for compulsory acquisition. What do you call the exercise of eminent domain? If the government wanted to exercise the power of eminent domain, that's a compulsorily acquired property. The Constitution, which we had upon attainment of independence, required that compensation had to be paid. There's also another restriction with respect to chieftaincy, that bills affecting chiefs had to refer to the House of Laws. I'm sorry, not the House of Laws, the House of Chiefs concerned. So if you are making a bill which will affect, let's say, that chiefs in Ashanti region, you needed to refer to the Ashanti Regional House of Chiefs. If it's going to affect chiefs in the Volta region, you needed to refer to the Volta Regional House of Chiefs, or Brahava region, or Greater Accra region, and so on and so forth. Again, if you look at the 19th Independence Constitution of 1957, the power to appoint, promote, and dismiss public officer was vested in the government of Ghana on advice of Public Service Commission. Now, judges could not be removed unless there had been a two-thirds majority of National Assembly. So unless the whole of Parliament, two-thirds, says that a judge should be removed from office before a judge could be removed. Now, against the backdrop of this restriction, let us look at some case law which came up during the period. The well-known case of Eladan against Attorney General. In that case, the plaintiff pursuant to deportation order, which had been made by the government under the Deportation Act of 1957, was to be deported from Ghana. Now, the plaintiff did not want the deportation to take place. So the plaintiff decided to bring an action, and by that action, it was to the effect that the Deportation Act could not be applied to him, that the court should declare that the Deportation Act was not valid. Now, his reason for seeking the intervention of the court was that he was a Ghanaian by birth. And if you're a citizen by birth, how can you be deported from your own country? So that was his argument. Now, while the matter was pending in court, the Parliament of Ghana, of course, which is heavily under the control of the CPP, they were in the majority, quickly enacted what we called the Deportation Othman Laden and Amadou Baba Act 1957. So just look at it. A case is going on in Parliament. You've made an order under certain law trying to deport someone, and then the person rushes to court to say that, well, I cannot be deported because I am not an ordinary citizen. I am citizen by birth, and being a citizen by birth, I cannot be deported from my country. Now, why the person is fighting that in court? Parliament passes a law which was entitled the Deportation to bracket Othman Laden and Amadou Baba Act 1957. And under that law, the Minister of Interior could order deportation of the two named individuals from Ghana, regardless of whatever was going on. And worst of all, if you look at Section 4, subsection 2 of that legislation, it sought to terminate any proceedings in any court which have been instituted for the purpose of challenging the validity of any deportation order made against the persons affecting the act. In other words, the new law was saying that, well, if an order has been made deporting you under this new law, no court could actually challenge that. And that was, effectively the point which was made. So if you look at the provision That is how the provision was framed. Because of time, I will not read the provision, but you can read it in your notes. So the question which the court had to resolve was whether or not the act which had been made while the case was pending in court, the case challenging the deportation, whether that new legislation was this to traverse the Constitution. Now, if you look at section 31 of the Independence Act, there's this provision, quote, subject to provisions of this order, it shall be lawful for Parliament to make laws for the peace, order, and good government of Ghana. Now, the judge who decided the Lardin against the Attorney General case was Justice Smith. Don't forget those days, we still had the expatriate judges as well. So it was Justice Smith, and this is what Justice Smith said, quote, I have considered all the other authorities cited to me, and they illustrate the same point that the West, peace, order, and good governance, with no reservation attached, no restriction as to specific subject, without qualification, give to any country the same plenary powers as are possessed by the Imperial Parliament in England. It was considered that this act of deportation, and that was a momentary indulgence in fantasy, if passed by imperial government, would be a matter for Parliament. Only an English court will be powerless to interfere. If, as I hold, the world's peace, order, and good government, unqualified in any way, are plenary powers possessed by Parliament, and no less than the powers possessed by Imperial Parliament, and it follows, just as it will in England, that the court here has no power to inquire into such an act. I consider, therefore, that any law which comes within the ambit of the Ghana Constitution Order in Council, Section 31, that is the 1957 Constitution, and which does not contravene any other provision in the Constitution, can only be challenged in a court of law if it violates or purports to violate subsection 2 or 3 of the section. On that view, the act deporting these two persons not being contravention of any express limitation in the Ghana Constitution Order in Council 1957 is a matter for Parliament. It is the same position in the case of South Africa, where the Constitution provides that Parliament shall have full powers to make laws for the peace, order, and good government of the Union. It has been held in the case of Ndwala and Homeyafa. Parliament will, therefore, as expressed in an Act of Parliament, cannot now in this country, as it cannot in England, be questioned by a court of law, whose function it is to enforce that will, not to question it. So if we look at it, unfortunately, the court also felt helpless or powerless to do anything in the face of the new Lardin Deportation Act, which have been passed. Now, similarly, in Balogun against Edusei, deportation order had been made and 4 persons were arrested. 2 days later, their lawyer applied to the court. Let me get just a cup of tea. Two days later, their lawyer applied to the court for a writ of habeas corpus. When we say habeas corpus, it simply means that produce the body. So let's say that somebody has been detained, the person has not been brought to court, for the court to grant bail or put the person on a remand. And the person is just being detained without any lawful authority. So you go to court and you let the court issue another court habeas corpus directed against the person who is detaining another one, for that person to produce the body and show cause, explain why it should not be made to release the person. So in this Balungu again, they do say 2 days after these people have been arrested, their lawyers applied to call for writ of habeas corpus on the ground that they are Ghanaian citizens and as such could not be the subject of deportation order. Notice was directed to be served on the Minister of Interior as well as the acting Commissioner of Police. The notice was served the following day, although 4 persons had a day earlier been flown out of the country to Nigeria. And the court found the Minister and Commissioner of Police to be in contempt of court. But the court did not proceed to sentence them for contempt of court. The court hoped that they will purge themselves of the contempt. That is, they will show remorse and apologize for the disrespect that they have shown to the court by flying the people whose case was being considered in the court already out to Nigeria. Now, on the morning of the adjourned date, Parliament passed a new law called Deportation into bracket Indemnity Act, number 47 of 1958. In other words, Parliament passed a law saying that anything which was done or failed to be done by the Minister or the Commissioner of Interior regarding deportation of these persons are forgiven by the law and not considered as wrongdoing to be punished. So it's indemnified, so indemnity is given. So the act exonerated the 2 persons from all penalties for contempt of court. And the same Justice Smith had the unfortunate duty of deciding that case. But this time around, this is how he rendered himself in the Balungu against the Re Akoto. By the passing of this act, that is the act by which they sought to exonerate those who had actually decided for contempt. This is how the judge rendered himself good. By the passing of this act, I take it that the court's finding that the respondents are in contempt is not challenged by Parliament, but that the intention is to neutralize any consequential order that I might make. It is plain that Parliament prefers that the respondents should not apologize and has passed this act in order to nullify any order which I might make in absence of the apology. The course of justice exists to fulfill, not to destroy the law, and it will not make sense for me to record an order which is incapable of being carried out. As to the deportations, while the applications for habeas corpus were still sub judice, I cannot overemphasize the undesirability. I cannot overemphasize the undesirability of interference by the executive with the functions of the court. Persistent indulgence in such a practice could not have any other than the most serious ill effect on the well-being of the country. Decisions of a court are as binding upon the executive as the laws which Parliament passes are binding upon the ordinary citizen. And it is the court that enforces upon the people obedience to these laws, thereby aiding Parliament in the ordering of the country. In the result, the finding of contempt stands, but I make no further order, unquote. So if we look at the reason of the judge was frustrated, but he was saying that, okay, if I look at the law which Parliament has made, Parliament is not reversing the conclusion that I made that these individuals are guilty of contempt. However, Parliament is preventing me from punishing them for having already been found guilty of contempt. And if that is what Parliament is saying, then I'll not go ahead and punish them. Yes, we shall now take questions. Bespoke Mahan. Yes. Bespoke Mahan, let's hear you. You can mute yourself. You can unmute.